Good morning, everyone. Thank you for joining us on this live World IP Day 2020 on Facebook. So we are glad that everybody is joining and keep joining us. So we are ready with our first panel. And before beginning, I will say thanks to our partners who have supported us in building this World IP Day. And we are thankful to each and everyone here. And we tend to bring a good IP ecosystem in our country, also in global part. And we'll start with the first panel discussion right away. And I will start introducing our speakers of the first panel. Thank you. So our first panelist is Shobhana.
Hi,
Good
everyone.
morning. Hi. So Shobhana is our first panelist. She's from US, and thanks Shobhana for spending Saturday night kind of thing. It's 10:30 p.m. there, right? And Shobhana, I request you to just introduce to the audience for a minute, and then we can introduce the second panelist.
So hi, everyone. This is Shobhana Farooq. I go by my name is pronounced Shobhana, and I am the CEO and co-founder of Founders Click, and it's an ecosystem with a global community of entrepreneurs, small to mid-sized businesses, professionals, domain experts, investors, and nonprofits. And all members are allied stakeholders in a small to growing businesses, and every member leverages Founders Click platform from their vantage point per their requirements to connect, promote, and to effect results. And we address 5 critical pressure points through our premium services: expertise leverage, lead generation and market expansion, funding, strategic connections, and team build. And thank you, Vivek, for your introduction.
Thanks, Shobhana. Thank you very much. So I will now introduce our second panelist. Welcome, Javier, to our panel, and thank you for joining us and spending early Sunday morning with us. And I request you to kindly just give a 1-minute introduction of yourselves to the audience.
Yeah, thanks, Vivek. So thank you, everybody, and to the sponsors as well. My name is Javier Paul. I live here in London, in sunny London today, early Sunday morning. And my role is I'm the co-founder of a company called WellTech. WellTech is a innovation ecosystem and accelerator program based in London, but covering Southeast Asia and East Africa as well. And we support entrepreneurs and investors to come together to solve problems, particularly in the healthcare space. So we support by giving access to capital, giving access to new markets, corporates, and expansion. And more recently, we support as principal deal advisors to a $150 million fund for emerging markets, and supporting to be able to deploy that money into emerging markets.
Thanks, Javier. Thanks for the introduction. So I will now introduce our third panelist, and I will bring him on the screen. Hi, Mrityunjay.
Hello.
Welcome to our panel. Welcome to our panel discussion, and thank you for sharing your thoughts, and thank you for being with us. And I would request you to kindly just introduce you for a minute to the audience, and then we can start with our discussions.
Thank you, Vivek. My name is Mrityunjay, but for simple, you can call me Jay. And I come from Bhubaneswar, the eastern part of India, the state of Odisha. I belong to a university called KIIT, KIT University, and I am the director of School of Biotech. I'm a professor here, but I understand very well business, investment, and fundraising. So I also run a technology business incubator at KIT called KIT Technology Business Incubator. And it's quite promising one in the country at the moment, and top-ranked TBIs. We promote mostly deep tech, IP-driven startup companies. And we recently also got the Center of Excellence from Ministry and trying to see that how do you build more manufacturings in this part of the country. So that's what we have been doing. And the government of India is quite happy on us. And we have been now already promoted 200 plus startup companies And really, a couple of them are doing good and raised a good amount of private equity fund. That's what you want to see, the eastern part of India also going to rise. Thank you.
Thank you, Mit. So thanks our panelists for your introduction. And I'm going to talk about few questions with all of you, which are generic in nature and which is understood by everyone who are listening to us. And since we are talking about intellectual property, right? It's intellectual property is, of course, will help you to have a good footing in your home country, but it will help you to have a good partnership in outside world as well, right? So I will start with my first question to Shobhana, right? And the question would be, uh, this is a very basic question which everybody asks, like at what stage a startup or an individual should think of exploring possibilities for a patent. So people are not aware at what stage people keep building a prototype, right? And they say, oh, now I have to build a file for a patent application. So according to you, Shobhana, what stage is appropriate for a person, individual, or a company to look for a possibility for a patent?
Sure. I think this is always a very interesting question because a lot of startups consider filing for patents at the outset cost prohibitive. However, I think the cost can be justified depending on its validity and criticality for the company. In some industrial domains, more important than others. So when I would say a startup needs to consider this when their invention maps strategically most to the company, current or in the future, or in some cases, if they feel that it can help outflank others in a competitive landscape. So that would be one parameter. The second one I would venture to add is when there is clarity, depth, and a certain amount of consistency, even if you're filing a provisional patent, or at any rate, a high rate of confidence that in 1 year, especially in the US, that you would have a solid IP backing. The third is what you mentioned, Vivek, which is when entering into a partnership, getting ready to negotiate with suppliers, competitors, and getting ready particularly for outbound licensing. So I feel strongly patents, even for a startup with the modest pockets and budgets, it can boost investment, it can boost fundraise, and on occasions can open up M&M opportunities. So I think it provides a jump start to startups to prevent competitors from using their technology. So you can either be proactive or you can take preemptive actions.
Thanks, Shobhana. So what about you, Jerry? What's your thought on this?
I think it's a difficult one because, if you think about startups from an early stage perspective, cash is not in high supply. Every penny you spend on, you don't spend on research, development, product market fit, activity that gets you customer. You're essentially not allowing yourself the best chance of the product being successful. At least in the small way, to show those small improvements to be able to go out and then get funding. So you look at it in that staged approach, it becomes difficult to then justify it to yourself as a founder to say, I'm going to spend money on something that's not the core of our activity, that's not achieving product market fit, because that's the biggest, most important thing for the early stage of a business is product market fit. So that from that context, it can be quite difficult to justify. But I think Shobhana hits on a very good point. If it's the right fit for that organization, so IP heavy organizations like biotech firms is a really good example of that. You have a need to protect some of that if you're going to engage in supplier conversation, if you're going to engage in other types of conversations with new partners. And therefore it's needed. In order to gain your product market fit, you have to have it. So justify it in the right way. I would actually say that justifying it by saying it increases my valuation is the worst justification. It has to fit with the business need, because if it doesn't fit with the business need, you've made a poor use of money. And me as an investor, I'm going to see that as a weakness, not a strength.
Yeah, thanks, JV. So it's another point of view from I would say entrepreneur and the startup friend, and it is one of the main concern which we always been hearing from the startups as well. So Jay, you have been one of the, I would say, richest incubation center in India, right? And how about you? Like how your startups look at this question, and at what stage you must be encountering the same question every day, right, with your startups? So what's your take on this?
Good. So, when you talk to startup, let's say, I'm from an incubation center, and here I differ from other two, Savannah and Javier, because, most of our startups are funded with IP, filing fees and management fees, because the government supports it. So very easy for us. So in our case, what we feel, there's no textbook for when to file IP. That's what the team has to decide. And a lot of IP, facilitation centers are there in the country. Like we have a technology business incubator, we have technology transfer office, IP office. So we help our startup when to file. So each company, the individual which comes to us with ideas, prototype, and all, we basically help them. Take them through a process, capacity building, and then they decide this is the right time to file. And I will also tell the startups, individuals, and it's not a game of how many you're filing and how smartly you're filing is important. So you have to take a call at what point you have to file an IP, which is going to create values for your company, for licensing out, or for your own company product development wise. So we see various kind of startups coming to us, but always solution for that. But there is no textbook or there is no mentor who can say this is the right time. So the startup have to go through a journey that this is the time where we should now file IPs. And people are there to guide startups, at least in India. Of course, everywhere there, a lot of people are there.
So, so Vivek, if I can make a point, I think Jeber and Mrityunjay brought up some really, really good points, and I cannot agree with them more. I think the alliance between Startup Buddy and Founders Click is designed precisely to address the issues that they both brought up, in the sense that we want to make an area that is cost prohibitive to an area where, when there is a need and the cost can be justified with the validity and the criticality to the company, that we step in as a team to offer that to US companies, especially startups, because that has been the delta between wanting to file, even in justifiable cases, and not being able to file. And we are truly trying to bridge that gap. And that, in my opinion, is an innovative approach, pun unintended. Yeah. So.
Yeah, sure. So thanks, all of you, to sharing your different views, right? And I would say the common point here is, like, one has to be vigilant about protecting their ideas, right? At some stage, they should look into it, right? I will move on to the next question, which has not been given a good importance or attention by the startups or companies. Like, startups. Why I'm going to startups and companies? Because everyone has to have a brand. So here we are talking about trademarks. So trademarks, people don't give much importance to a trademark. But if I talk about that, Procter and Gamble is one of the global leading company. They have 50 brands, and each brand has $1 million to $1 billion value. And it's only the name they have carrying the value. Like we can see Google, right? So I want to bring out this particular, I would say, point of attention to everyone who is listening to us, that besides patents, trademark is also important. And my second question is based on the trademarks only, that what is the significance of trademark for a company? How does it help to building a brand value? And I'm talking about the monetary value, because we see that Google has $1 billion value of the brand, and the McDonald's have a value, Apple has a brand value. So how important for a startups is to give heed to the trademark and protection of the trademark enforcement, and what is the significance Like we can start with the Javier in this case. Like Javier, about your trademarks, like if you can just throw some light on it.
Sure. I mean, I, like most people, don't put huge amounts of value on a trademark because, first of all, enforcement of trademarks is challenging, is difficult, it's time consuming, costly. There's not much point as a startup to push yourself to try and enforce a trademark, actually, in reality, because you're too busy doing everything else. So I think from a trademark perspective, there are companies out there, and you've named some of them, who have the ability to enforce and protect their trademark. So great, but in reality, trademarking too much of your brand can be a negative point rather than a positive point. It's useful. It can be useful sometimes. Do I think that it increases the valuation when you come to me and ask me for, some money? I disagree. I don't think it increases the valuation particularly much. The thing which increases the valuation is if you've got a trademark and you've got your IP protected and you've got customers and product market fit. If all of those things are together and the product market fit is actually playing in, then I would agree with you that having the trademark is a nice to have. It's a nice thing to add on to that kind of selection of things. But if you haven't done the core of things well, you haven't got your product right, and you're not able to go out and scale it, then having a trademark is useless.
Thanks, Javier. So giving us I would say, a good point of look, right, towards the trademark. Jay, what about you? Like, what's your take on significance of trademark?
Right. I agree totally with Javier that the startups should not, or at the moment, they should not look at the trademark. Rather, they should focus on more IP part. But having said that, once you grow, you scale up, you know where to get your trademark. So there is time for it, and I think they have to grow in the business wise, the client profile wise, not on filing, the trademark or getting into that. But in incubation centers, we do not have those kind of people. They always come for IP protections, and but not for the trademark, because they have to really grow big. So you have a company, for example, the company called Far Eye. They say the brand company Far Eye is a company called Robotic Waste Private Limited, and they've been raising quite good amount of money. I think last week they raised 25 million. Earlier they raised around close to 35 or 42 million dollars. So these companies are now putting their trademark. Not at the very early stage of startup, they should get into, but they have a lot of IPs, patents. They have a lot. So I totally agree with Javier that startups should not focus more on trademark, but more on IP filing and IP management. That's the best part.
Thanks, Jay. So, Shobana, what's your take on the trademarks?
Well, I agree with most of what both our panelists said, except I have a slight difference of opinion in that I believe trademarks, not in the early stages, I don't think so, but as the brand is built, and brand build and market visibility for products and services is a given necessity, even for lean startups with a modest budget. But what happens then is, at least in the US, when there is a brand confusion after you have spent a lot of effort in a brand build, legitimizing its business usage in a geographic area, and then you want to expand to, let's say, as the Founders Clicks Conduit Click service does, to a different market. At that point, this investment that you make, which is far less costly than a patent, can pay off in terms of preempting legal costs and marketing issues, responding to demand letters, and in some cases, a costly rebrand if that probably is the only solution and a viable choice in that different market. So a slight twist to what was being said is that I would look at a trademark, certainly not from day one, but a little bit down the road when you have started putting some efforts into visibility, and to file for a trademark, which is far less costly than a patent. Trademarks are, again, in the US, is a forever asset. So, for instance, Pepsi, they have the trademark since 1890s, and they still have it for today. So it's an asset to have, and it is used sometimes as collateral for a bridge loan, patents and trademarks. So if a startup hopes to expand, sell, merge, raise funds, I would definitely say at least think of trademarks after you start putting some money behind a brand build.
Thanks, Ravana. So I will now take one of the question which is came from the comments on the Facebook, which is, what about the trade secret? So I think we can start with Shobana, with you on the trade secret, though there is a codified law in US. And so we can just take a minute and just talk about the importance of trade secret.
Yeah, trade secret, the moment you make it public, it simply goes away in the US. It is a very interesting, it's a very interesting concept in the sense that it is a confidential information and you want to protect it. But yes, through a non-disclosure agreement, you may want to look at your employee contracts or employment contracts and ensure that any kind of valuable information stays in-house. And especially for developers, or if you are, if you think even your business process is a trade secret, is to let the appropriate people who are speaking to outsiders to either have an NDA or not disclose it at all. Because once you reveal it is in the public domain, even in a regular conversation, the oomph, the impact of the trade secret is minimized.
So what about Javier? What's in UK? Like there is I think there is a law in trade secret also for UK and IP.
Yeah, it's interesting because globalization is an important concept when it comes to trade secrets, right? Because each place has their own different approach to how do you deal with disclosure of information, disclosure of trade secrets. And non-disclosure agreements in the UK, while they're used very heavily, are generally not very enforceable. They're generally there to make people feel nervous about stealing trade secrets, more so than having a legal enforcement, and to define a relationship more than anything else and allow a relationship to progress. So you've got to make a decision at some point as a company of, if you don't share information, your business doesn't grow. If you do share information, then you're in a place where someone may take some of it. For the digital startups that we work with on the digital health side, actually copying is a great sense of flattery in a way. It shows you that you're onto something. It gives you a way of thinking that you're in the right direction. And innovating quicker than your partners around you, having a product-focused mindset is actually the biggest protection against competition and IP theft, really. Because if you can move faster than your competitors, then you're giving product sets which are sticky, needed, used well. If you're in a more of a biotech scenario where it's a core product is your whole product, essentially. When I say product, I mean a formula. It could be a peptide, it could be whatever it is, an organic drug. If you share that, the secret's out. And oftentimes there's large pharma companies waiting in the wings to try and work out what it is, who can build it much quicker than you. So in that scenario, you need to be much more reserved about sharing your trade secrets. And if you are going to do it, seek the right advice before you do it, is my view.
Yeah, thanks, Javier. And Jay, so in India, we don't have a law for trade secret, but must be startups and must be asking you questions about it. So what's your take on this?
No, that's true. We don't have a law because also it's now evolving in India. There are a lot of discussion, capacity building program people are talking about that, how to also formulate this. But as both have mentioned about, the trade secrets are, just like the formulas in beverages, you know what I'm talking about, or maybe in some pharma industries, and you really want to have IP on that, you can go for it. But Indian context, the IP laws are very different kind. Sometimes knowingly startups are also failing because people are copying what they've been doing. So they don't keep it public, and if they want to, they also sign a couple of NDAs. And it's all evolving in the Indian context. So I'll not talk much about trade secret because it's not concrete in Indian context at the moment.
Yeah, yeah. Thanks everyone for your valuable inputs on this question. So I will now move on to my next question, which is the major impact for everyone who is into research or who is doing innovation. So people are doing a lot of innovation, but they don't realize that this is an innovation, and they don't end up in at least checking whether this is patentable or not. And this is my observation, since we work with a lot of universities and research institutes, even few MSMEs. They do a lot of innovation, but they don't take steps towards at least checking what is patentable or not, right? So how important, like in your experience, is it to realize the innovation and takes towards protecting it? So how important is it in your opinion? We start with Jay. What's your opinion on this?
Good. This is very interesting for me because I've been handling this. Um, Now, look what startups are doing. So there are different kind of startups, more into service sectors, IT-enabled service sector. But what we focus on mostly tech enables the startup company into manufacturing, into process development, to new service development. Now, these are all IP driven companies. And what we do, we run a couple of programs called IP capacity building programs. So that is going to enable startups to understand that the value of IP, because most of us, we keep on inventing, discovering things and building new product, new technology, new design, but we forget about the IP part of it, because startups are not able to pay really the IP professionals. So that's why when they come to us, we have a very full-time IP guys who really help these startup companies. Now, having said that, if you're building a tech startup and you know that you want to get more revenue, more investment in future, you need to build your IP, the innovations part, very, very strong. And of course, the claims you have to build in such a way that the others cannot encroach to your discovery, the innovation part of it. But most of the companies, those who come to us at very early stage, they really need to work on the innovation part, the proof of concept part, the product part. So the here in Indian context, what is called a product is something, probably people say, I have come with a product. This is not the real product. This is far away from. I think they have achieved only 10%. And for that, I'd be suggesting that the startup to really build a strong innovation component, and which may not be just to file a patent, but to really value your company, to more valuation of your company. So I'll most of our company in the kit TBIs, or in the Indian context, many of the startups are coming with a lot of IPs, and you'll be very surprised in our centers. I think all companies have got their IPs, and our IP centers are going to help them. And the government of India is now pushing this. Just I want to divert a little bit here for the audience benefit. If you are really developing a technology-based startup company and you apply, I think most of our startup company, KIT TBI, many of the Indian TBIs are funded by government of India. And there is one clause: if you're really building IPs, a lot of the funding also can be put in the IP management, IP filing and IP management. So startups should not worry about where to get money for it, because Indian government is quite generous these days. You go to NRDC, you go to DST, you go to BIRAC, you go to DBT, all these funding agencies who really fund startup companies for tech-enabled startup companies. I think IP is one of the most promising, the priority component in the funding part of it. So all of us, we are pushing IP in this, and this is very important for a tech-enabled startup company. Everybody must,
Thanks. Yeah.
thank you.
Sure. Thanks, Jay. Thanks, Jay, for your valuable input. What about what's your thoughts, Shabana, on this? Like, how
Yeah,
important it is to.
yeah, I think it is important to understand, first of all, the definition of innovation, right? Every pitch that I've heard from entrepreneurs, they think that their idea is an innovation, right? So you want to actually define innovation as to what is it? Is it a new idea, creative thought, imagination? And so, or even a device, or right now, so for a process patent, a method. So essentially, I think the way I look at innovation is something is an application or a device or a method that not only meets the current market needs, but also projected needs and needs of requirements that are yet to be conceived. I think that is where I think either Jay or Vivek, you brought up the point of research. I think the research is important before you file a patent, because a patent is important, and that's probably why there is a 1 year provisional 1 year time to file a patent to really see if it would stand up to the scrutiny of the examiner. Patents can, it's a catch-22. You have to file a patent if you feel in your bones it's innovative, because they can attract capital, particularly corporate capital. There is always this proverbial example of Lockheed, which had some patents in a 3D flight simulation, and they rolled this out as a separate startup called Real 3D, and it was one of the innovative startups which was just built on patents. So there are some reasons why I think whether it is pure innovation or whether you're not sure, but it can be border innovation or even a process method. For instance, everybody thinks of tech patents, but Dell, for instance, has over, I think, 40 plus patents just in the system of selling, distributing, and providing after-sales support for their customers. So patents in design, patents in process can be equally, perhaps more effective in defending proprietary rights to retain that competitive differentiation. Patents, I think, and the innovative patents, even provisional patents, when investors invest, I always look for, I think a lot of due diligence, discriminating investors look for do the due diligence on the depth of IP to see where the innovation is before they invest. So innovation and patents go together, but patents sometimes are needed to block your competition. Sometimes a cluster of patents are needed to protect your product. So it's something you've got to do, but with the knowledge that innovation can be something that is only ultimately determined by the market, by not just being granted the patent, but how you're able to leverage it for acquisitions and for building ROI. Because once a patent is granted, it is a sunk cost, but you can get ROI through licensing and so on. So that's my take on innovation and patents.
Thanks, Shabana. So we'll come to Javeer now on this part. So Javeer, what's your take on realizing the innovation and taking steps towards it?
So, I mean, starting at the macro level, which Jay, you put quite well as well, I think a lot of real good innovation starts in universities, particularly here in the UK. I mean, we're very lucky to have some of the best academic institutions, and they're all doing translational work. They're all doing work on various different innovations, and so a lot of funders particularly attach themselves to academic institutions because they can see and realize good IP very quickly. I think some of the best funders out there also help people with emergent technologies and innovative technologies that they may not have the capability to scale themselves. And I think that's also a very interesting point on innovation is when as a funder, can we notice that this may be a very fantastic piece of technology, is maybe a fantastic piece of IP, but the team may not have the right skill sets to be able to go out and scale. And we see that very, very often. So one thing that we do very often is we put in place people to support that team in a various different areas that they may need, product being one which happens very often. And Jay, it's refreshing to hear somebody else talk about product in the same way that we do. And we often see the same problem, that people are coming with a vague set of ideas rather than an actual product. And then on the other side, what I would say is that people in the startup industries generally focus towards getting customer very, very quickly, and says, I need to go out and I need to acquire customers, and that's the thing which will get me my valuation. When actually what they don't realize is they've gone out with the wrong product. They haven't done their homework and their research to test what is the right type of product. That leads to a huge amount of churn. And particularly when it comes to SaaS businesses or B2B businesses, you generally see a case where churn is very high, stickiness on the product is low, lifetime value is fairly low. And if I look at those metrics, no matter how many customers you have right now, I'm not going to invest in you because you haven't got your product right. Whether it's protected or not, the product isn't correct. And so that leads you to then sort of pull away as an investor. So the patent, I think, is very important. One thing that the investor can help you with is the patent itself. So do you need to have it in place when you go to investment? Probably not. Do you need to have identified where you have IP and where you're going to protect your IP moving forwards? Definitely so, because that's a conversation that you need to have with your potential investors.
Yeah, thanks, JV, for giving your thoughts from side of investors. We would be having a separate session during the day, right, for the investors at 1 to 2 p.m. India time. Mm-hmm. And my next question is related to in-licensing.
Hey, Vivek, can I interrupt you for one thing for the benefit of audience? Yeah. Because we meet these guys, they come with always with provisional patents. And also I think Shobana mentioned about it. This is okay to have provisional patent, but it doesn't have any meaning at the moment because, you've not filed the full patent. So when the startup is, filing patent, they have to really invest a lot of time, the understanding, the claims. Otherwise, your patent will not be meaningful after once you want to realize, capitalize on your IP. Because you see others companies have done, because right now, others have filed what kind of provisional patents nobody knows about, not in the database now. You're not searching those things. So can you really work on your IPs? The full patent is more important for the investment purpose. Almost 90% tech startup, they come with provisional patent, but we've realized this doesn't have much of meaning in maximum cases. So they have to really put more time in the full patent applications.
Thanks.
Thank you.
So my next question is related to in-licensing, and we have a question from one of our viewers, right, which also relates to the licensing of patents. So I take up that question and will merge it, right? So I'm just showing from Ramji. So according to him, that he's saying that protecting IP is important for both academics and startups. However, why there is a difference in IP valuation at each of them when transferring technology, and any light on that? So what's your take on this? Like, how in licensing, for example, a startup, right? We know about that Uber have licensed or taken a patent from AT&T to grow their patent portfolio at an early stage, right? So according to you, and we'll start with Jay here, right? According to you, Jay, when there's an academic goes to transfer of technology, and when a startup goes for a transfer of technology or a merger, so is there a difference in the IP valuation? And if it's there, then why? And your take on this part.
Good. So I know Ramji, this guy who's asking questions. So he's from CCMB Hyderabad. He's a very tech guy. So let me tell you now a couple of examples. So when you were talking about startup companies and academic purpose, academician, and academics' interests are different kind because they need to build technologies and need to transfer technology because they're not building startup companies, at least in Indian context, most of them. Now, for that, the understanding of IP valuation, the tech valuation is not that, very focused of the academic institutions or the R&D organizations. When you startup companies, many of the startup companies, the business plan lies on IP valuation. So they are quite smart guys. The same technology, if you give it to a startup company, the same technology give it to academic interest. When the tech transfer happens, you find the startup guys are much smarter most of the cases, because they want to create values out of more these activities as compared to academic one. So I'll say this is an art. This is a trick. This is strategy. There's a negotiation value. Who is negotiating and who are the member who is negotiating and who is the guy who is taking your technology. All depends on this thing. It's all about the negotiation part, and how do you see making documents are very, the people are doing it, but it never happens as such 100%. So it's all about the negotiation skills of the team, both the startup or the academic fraternity. It all depends on them. There's nothing called any rule for that, but yes, it all depends on the skills of the.
So what's your take, Shobana, on this? Because in US, both things happens, like startups do license and academics also. So what's your take on this question?
Yeah, so there are university accelerators. I think Jabir mentioned that. And so a lot of startups, technology or otherwise, I think are spurred on by technology developed by the student while they are a student there. And it certainly creates new products, for service and market opportunities for themselves. It reduces, saves rather time and cost in getting a new product to the market. So there are some definite advantages to the licensee. It reduces costs to acquire new technology. Sometimes this can be justified to an investor as a usage of funds to be able to acquire this technology, and of course, assuming you have, a business plan and a projection to take that forward. But if positioned as a revenue channel, it certainly raises the prospects for fundraise. In US, there is something called an express license, particularly by the accelerators. With startups in mind. It's a predefined template designed for rapid and streamlined review process. I think you get it within 30 to 45 days, and generally the license fees are typically deferred with a convertible note. While the terms of the licenses may not be as easy to negotiate, it still accelerates the process to acquire the technology. But as Jay was mentioning, I think in terms of licensing, it is a process. While it's very easy to say, yes, I can license it and it can be a revenue, and this is from the licensor perspective, I think there has to be a definite, a mutually beneficial process and a reason for licensing, because a brand may be at stake. It's like a marriage in a way, and we want to make sure that things are ironed out upfront, and you go through the process to make sure you're doing it for the right reasons, not just for ready revenues, because some of the disadvantages of it can be that if the licensee does not, whether expectations of what you're trying to do and the licensee's objectives in implementing what you wanted to do are different, then it can be very, very problematic. I think it's important for the licensor, rather the licensee, to check on the track record of the licensor. I think whether there is any existing research and development and joint venture arrangements restricting the licensor use while the licensee is in fact being given the rights, maybe in a limited way. There are all these little nuances that definitely I advise getting the full legal support before anything is signed. And once again, due diligence by both the licensee and the licensor is extremely critical to help this succeed.
Thanks, Shobana. And what about David? What's your take on this?
So it's very challenging, and Jay and Shobana, I think you've raised some really good points. But particularly something that resonated with me, Shobana, was when you were talking about the difference between academics and startups, and the fact that licensing IP is a function of the due diligence, essentially, that you're willing to take on your license agreement and what's on the table in front of you. And I think startups jump too quickly sometimes at saying, I've got an opportunity for revenue, therefore I'm going to put out my technology that's patented, and I'm going to license that to somebody, because they don't realize that sometimes that oftentimes that's large company to small company. That's normally a large established corporate to a startup. And eventually what happens, it may be 2 years, 3 years down the line, but eventually what happens is the patent is circumvented by them having innovated on top of your product. And it's the next thing that comes along. And I think that's the difficulty, is how do you know when to license and when not to license, and having that right team around you to be able to assess that is very important. And that comes from advisors and good advice. The other thing I'll say about the difference between academics and startups is that academics generally come with an idea that's been well crafted and academically researched. So you've got some validation behind it. A startup, when they're licensing something to somebody, often comes with a much more comprehensive wraparound. So they will have had the research done. There's an operational process on how to use it, and some know-how there. There's some support that will come alongside the use of the license. So in terms of the validation and the valuation that then comes from licensing IP from a startup, I can understand why the valuations are pushed up. There's also the sad reality, and I think Jay alluded to this earlier on, that most academics hold positions with university, and those universities will enforce clauses in their contracts, will enforce all sorts of things to try and stop them from being able to financially benefit without the university benefiting from technology which may have been developed while they were employees. And that's often a challenge. It's not something which I've seen anywhere has solved particularly well. In Israel, they have a much better relationship with academia than anywhere else, actually. But most of the rest of the world hasn't got it right.
Yeah, if I can add there, I think that's a very good point. There are some exceptions to the rule. Bose Corporation, the company that is a leader in audio technology, they do a very good job. In fact, Amar Bose, Dr. Bose, was a professor in MIT, and they figured out a way in making sure that the research that is done is licensed back to the company and perhaps to some other startups as well. And there's one other point that I wanted to make, which I've found always problematic as well, is the delta between the licensee's expectations and the licensor's objectives and notifications. So as Jabir rightly pointed out, if the licensor happens to be a bigger company, they are always concerned about their bottom line and share price. Most likely they are a public company. Whereas for a startup, which is the licensee, they are typically looking at enterprise value rather than revenue and non-commercial milestones.
Thanks, Shabana, for adding on to Javier part and providing the specifics, right, the company needs. So I will go on to my last question, right, and I will relate this to another Facebook comment or Facebook question from this. So my last question was, what are the consequences of not protecting IP, right? And this particular question will relate to where Anand has asked about how about software source code and copyright. How is it relevant for the software product company? So most of the era in which we are living now is in digital era, right? So Jay must be having around 60% startups into the digital domain, and Javier, you are also into the digital domain, and Shobana, founder clicks, right? Everything is into getting into the digital domain. So how it is important for innovators? I will phrase my question here, for innovators who are into software industry or digital industry. How important for them to protect their intellectual property either by trade secret, copyright, patent. So how is it important for a software product company to ensure that they protect their innovation and their product by way of intellectual property? So we can start with any of you.
Javir?
Yeah, sure. I'm happy to go. I mentioned it earlier on that I think the focus towards protectable IP in a digital era is difficult, right? I mean, it's easy to copy things. It's easy to spin up products now. You can get something built very quickly, quite cheaply, and test it. The thing that's harder to do and the thing that we don't see very often is people don't take an approach which says, I'm going to test a component of my technology, and then I'm going to build upon that component, and then I'm going to test monetization at the next round, and then I'm going to keep iterating by making sure that I'm building product sets that people want. And that doesn't happen. So for me, that's the bare minimum. So if you've not done that, protecting your IP becomes irrelevant because your company becomes irrelevant in a way. So that's more important to me as investor and as entrepreneur. Protecting your source code, you have to do some very simple things, and protecting your technology, you have to do some very simple things like knowing who you're licensing anything to, making sure your suppliers are signed to contracts, making sure your employees are signed to contracts, and using simple things, using company accounts for GitHub, and using things like GitHub in the right way so that people are using the source code in the right way. That's something that we actually do quite a lot of in due diligence, is making sure that digital assets are being protected even at the company level. But then the other thing I would mention just finally on the digital side is making sure your digital assets are mapped, understanding your digital assets, and then moving forward from it. And using that as a stable base is very important. Because if you don't know what you've got as IP, you don't know who it's licensed to, you can't then actually go out and protect it. So knowing what is IP and what's not is also very important.
Yeah. Thanks, Javier, for sharing your entrepreneurial side views as well as from the investors' views. And Jay, what about what's your views on this? Because India is a very specific situation that computer program per se are not patentable, right? So yeah, what's your take on this?
No, that's what he mentioned about why because it's copying is very very it's a natural phenomenon everywhere in the world, and very fast in Indian context. So digital platforms are maybe you have to put somewhere something which people are not going to copy it. However, there are the rules coming up, changes happening, that how to file IP. Not the software is a product, but how do you build a software linked to a hardware. So how do you complete package you can file a patent is could be a more important part for a startup company. But yes, that's what all software companies are facing at the moment for the IP perspective. But yes, you look for some copyright things and see that at least you have something in your hand to showcase investors, and already you've got a patent in your hand. And this platform, Vivek, I'll just mention about it because Indian context, the IP, the tech transfer, these things were not happening at a random scale, like massive scale, like in UK, Europe, and in US. But today, the government is quite proactive. Almost all ministries now pushing it. IP centers coming up in most places. Now we are being educated on that. Then they're also building tech transfer officials. And then right now, the World Bank funded, first time in Indian context, I think 5 or 6 centers, the technology business incubator centers are given a huge fund. It's a huge fund with, I think, almost 20 manpower who would be, helping startup to file IPs, manage, help them to manage IPs. They will not, of course, not manage their IPs, help them to manage IPs, and also help them to do the tech transfer activities. So they are called TTOs in 6, I think, centers, and KIT-TBA is one of it, IKP, CCAM, Venture Center. It's more deep technology, biotech, and material science-based, technology transfer activities. So I think the startups, individuals, they have to be very, very vigilant. They have to also build the capacity of themselves or the team and see that, every time they're becoming more and more smarter. That's what I think I'll be requesting all of them, because everything cannot be given by the other part. They have to also build their own strength.
Thanks, Jay, for sharing the information. And I think who are all the viewers can take note of it that there are help available with the Indian institutes, and you can connect with Jay and connect with us, right? So we can help you to get your licensing done. So coming to the Shobana, what's your take? Like, how is it important? Let's coming to the software part, right? It's important to protect your IP.
Yeah, so I'll try to touch on some of the points that were not touched on. Some unique ones that are starting to show up, and one of those is the liability to the board and the liability to the investors. So when there is a potential patent infringement. The reason for it is the failing to make best efforts to steer a company as part of their fiduciary duty to steer R&D away from potential infringement is seen as a definite legal liability. So for some companies, especially the ones that are leaders or close to the leaders in the market, this is one thing that the board included should be focused on in their own interests. Secondly, I think it is smart to stay relevant, to have patents, and many founders, and for unjustifiable reasons that we all have discussed so far, is to be unnecessary to spend the time and money. But I think it will pay off. Anything in IP, I think when there is an issue, that's when its importance rears its head. So it's very important to spend the time and money to not just file patents, but also to map out the patent landscape to avoid infringement dangers, because it's an uphill task to go fight that. And we haven't talked about infringement of trademarks. If you want to expand to a different company, let's say through Conduit Click, in something like this, it can cost your company the brand and logo and the goodwill associated with it. So it's important to sort of plan ahead. I think we talked about it when we spoke about trademarks. And the other thing is that we haven't, there's one other point, and maybe it was discussed, but it had to do with copyright infringement. In US, unlike patent and trademark laws, there are express damages written into the copyright statute. So it is something for companies to think through. It can be a gotcha moment if that happens when you least expect it. So there are consequences, mostly financial penalties, but it can also impact brand. It can also impact your potential exit option when due diligence reveals that there can be potential patent infringement and you lose the value of the patents. So it's also important to have a cluster as well as a bracketing, I guess, strategies, if you will, for your patents.
Thanks, Shobana, for providing your inputs. So one of the most and oldest example of not respecting others' intellectual property and how important to create is Harley-Davidson and Indian bikes case. So when Harley-Davidson has started manufacturing their bikes, they didn't look into the patent of Indian bike company in their clutch walls. And when they manufacture their bikes, they got infringement notice from them. And they have to sell off all the bikes and they have to start from zero. But this is a good example that Harley learned from that and become a Harley Davidson today. So yes, it's really important to protect IP. Now, I think we are at the end of our a very, very informative panel discussion, and thanks to everyone for your sharing your valuable inputs. So before we leave, like I will just I will ask you to spare one more minute and your advice to all viewers, all startups, individuals, and companies about intellectual property. Our topic was impact on IP valuation. Yes, it does. This reflects from our discussion. But what are the last pointers that you want to give away to the audience? Like for 1 minute, if each of you can speak and let us know. We can start with Shobana. What's your take and what's your advice to everyone here?
Yeah, so as I mentioned, intellectual property for a company is an asset. It's an asset which can be a collateral security. Interestingly, it's for getting a loan, for sometimes as a recognition of it through company equity. So it is something where you do get return on investment. The question is the timing of when you file certain things, when it makes sense, not just for having something on paper, like Jay mentioned, a provisional patent, not just that, but some meaningful reasons why you want to do that. It's a long drawn process. You got to have patience. You got to see it through. I think trademarks are easier assets. Hopefully something that you think further ahead. It's very, very important that you think ahead in trademarks and go for it. With patents, I think it's important that there are companies which just specialize in buying and selling patents and building a company on it. There are startups who start it and then take their ideas and try to build patents around those ideas. So the different ways their journey and paths take. But whatever your journey is, your path is, I think having a healthy respect for IP in whatever form is important, because you never know how important it is until you are faced with an objection, with a lawsuit, with a demand notice. So as hard as it is to enforce, I think these things are distractions that you should avoid. And to all the entrepreneurs out there, I wish you success. And in fact, Founders Click with Starter Buddy Alliance is trying very hard to provide that service through its Expert Click service to bridge that, or rather to answer that conundrum, if you will, to bridge that gap between costs and value. And so, and hopefully, if you are interested, please do touch base with me or Vivek. Thank you.
Thanks, Shobana. Thank you. Stay with us before I do concluding remarks. And I will bring on screen Javi for his final comments. Hi, Javi. So,
Hi.
yeah, please share your last one.
Yeah. So look, so I've said it a couple of times through the conversation, but I think the message to drive home for me is if somebody is going to steal your IP or to try and steal your IP, it's generally going to happen. They're going to, if they've got enough will, they will do everything they can to try and do that, particularly larger companies interacting with smaller companies. So the game is in trying to make that as difficult as possible. And so, you know, the things which are easier to do than patent and going down some of the legal routes are making sure that you are focusing on your product. So know your numbers, know what you're focusing on. And make sure that people value your product enough to use it very often. And that's one of the strongest ways of being able to protect your product. You know, early days of Google is a great example of people valuing their product more than other search engines that were out there. And I think we all kind of remember those days. And so I think very much focus on your product is the first message. The second message for me is know the right time to be able to apply for your IP filings, and do that in collaboration with your investors, not as a conversation to try and bring them to the table. So it needs to be done collaboratively with investors and your advisors and your company to fully understand when is the right time to do this and when it's the right time to spend money on doing this as well. And the third thing, which is actually something which I've learned on this call, and I may be stealing some of Jay's thunder here, is that there's such a huge kind of diversity in the numbers of people who are helping you on this subject. So go seek advice, because it sounds like there's a lot of advice out there that people are very freely offering up to help you. So go seek advice would be the third point. So yeah, that'd be my main comments.
Thanks, Javier. Stay with us, right? And I will now go to Jay for his concluding remarks. Hi, Jay.
Yeah.
So if you can
Yeah.
share your conclusion.
Sure. So I think the stealing IP is a business plan these days. So I think those who are filing IP, they must be smart enough. Do not give excuses. Do not think that people are not going to copy it because you file a IP on it. They're going to, steal your IP because they're smarter than you. So I think when you file your IP, talk to peers, talk to the real, the IP, the stakeholders, the IP promoters, agencies, the individuals, and bring the strongest claim in your IPs. This is going to make you survive in long run. Apart from then, those who are from Indian context, I can tell you that IP is a strong component in building your enterprise in long term. So if you are really building tech-based enterprise, focus on IPs is very, very important. And government is very keen to support it. All ministries supporting it. And let me tell you, the funding in Indian context is not a problem today. Startup India, Invest India, DBT, BIRAC, DST, TDB, everybody is pushing MSME, everybody is pushing the IP component in tech-enabled startups. So I think be smart, start to know things, and every day you should learn new things, and then build your expertise, and automatically you'll be a winner in long run. Thank you, and all the best.
Thanks, Jay. And thanks, Jay. Thanks, Shobana. Thanks, JV, and for this insightful discussion and sharing your thoughts and spending your valuable time on Sunday, right, and Saturday evening for Shobana,
Mhm.
right? And from this, what we got to learn is that IP is important, and you have to realize its importance, and you have to calculatively decide at what stage you have to protect it and what you have to protect it, because disclosure is amount to do, like filing a patent is amount to disclosure. So you have to be very calculative in disclosing your innovation, your trade secrets, right? And we are happy to, though we are able to take few questions from our live session. Those questions which are unanswered, they will be answered over the email. Please share your email in the comment section. And if you have any question from our experts, we will have your questions answered from them over email. And from now, I thank my panelists, and I thank you everyone for watching us. And stay connected for our next session at 1 to 2 p.m. And thank you, everyone. Thank you.
Thanks,
Thank
everybody.
you.
Thank you, Anna. Thanks,
Thank you.
Javi and Vivek.
Nice to meet you,
Thank you.
Javier.
Nice meeting you.
Likewise. See you. Bye.
Bye.
Thank you. And go for sleep now.
Thank you. Thank you.
Okay, bye-bye.
Bye.
Bye.